series this morning. We are going to go ahead and get started. Thank you for those of you who have been waiting on the line for us to begin the webcast. This morning we're going to be talking about a very important and rapidly changing area of the law that affects just about everyone who does business internationally, and that is the laws that govern bribery and corruption. Bribery and corruption sound as though they are very insidious and would be easy to identify practices. However, because of the murkiness of the law in a number of key jurisdictions, the lines between normal business practice and what runs afoul of the law are rapidly changing. We're very lucky to have with us this morning Sue Snyder, who is our International Legal and Trade Advisor. Sue is a recognized expert in the Foreign Corrupt Practices Act and in the new and rapidly changing UK bribery law. We'll go ahead and get started with the webcast this morning. For those of you who may be having trouble viewing the slides but are on the audio, you can contact events@vitalwaveconsulting.com. We do understand a number of people have had some slight technical issues, and we're happy to assist you in getting into the visual portion of the webcast this morning. The webcast will also be up on our website so that you can access it going forward if you do have trouble with the visual portion of the presentation this morning. So today we're going to do a very brief overview of Vital Wave Consulting and then proceed with a fairly in-depth review of the corruption and bribery laws as they currently stand. I did want to say very clearly from the outset that this briefing, while it covers the law, does not constitute legal advice directly. However, if you have questions about either the contents of the website or what is in the law, please do feel free to contact us directly, and we would be happy to help you work through the intricacies of this issue. To introduce myself, my name is Ann Crabe. I've been with Vital Wave for a couple of years. I handle a fairly broad range of areas. I've worked in healthcare, agriculture, and information technology with Vital Wave Consulting across a broad variety of markets, Africa, India, and elsewhere in Asia. I also have a background in the semiconductor industry and have worked extensively in China and Korea and a number of other international markets. During my tenure in semiconductors, I had the distinct pleasure of working with Sue Snyder, who for many years was counsel inside of Advanced Micro Devices. Sue now is an independent legal advisor, and we're very pleased to have her as part of the Vital Wave team. Sue, can I ask you please to take a moment and introduce yourself?
Sure, Ann, and good morning or afternoon to everyone who's joining. It's a pleasure to speak with you today. I have had the pleasure of working with Ann in the past as well. I have been an attorney for over 20 years and have practiced the majority of that time in the international arena. I've been both in-house counsel, a vice president at a Fortune 500 company, and also a partner in a law firm as well. And I currently am teaching at the Macomb School of Business here in Austin, Texas. I teach international business, ethics, corporate social responsibility, and business law as well, and also provide some additional consulting services in some of these arenas too. I've worked in over 40 different countries around the world and have had the pleasure to work in international trade as well as international endeavors for various companies in those locations. So it's a pleasure to join all of you today.
Thank you very much, Sue. And I realized that as part of my introduction, I neglected to tell our audience how to submit questions. On the right-hand side of your screen, as part of your GoToMeeting dashboard, there is a button for submitting questions, and we would welcome you to submit questions in writing during the course of the webcast. And we will endeavor to answer all of your questions during the course of the webcast. Any questions that we don't get to, we would be happy to answer after the conclusion of this call. So please go ahead and include your contact information if you don't mind with any questions you would like answered. With that, we're going to go ahead and turn to a quick overview of Vital Wave Consulting and the services that we offer. The firm has been in business in Silicon Valley for 7 years, and we offer a wide range of services covering, centered primarily on the technology industry. We do telecommunications, IT more broadly, health with a focus on E and M health. We're very involved in financial services, again, with a focus on E and M financial services across the full range of emerging markets. We also have an active due diligence and risk assessment practice. The markets that we work in are truly global. You may notice a couple of these on the slide are not emerging markets, but our focus primarily is in the emerging markets. Central and South America, Africa, and Asia. We have broad teams on the ground in most of these markets and regional expertise. We have the ability to supplement in-house resources and also to act as external consultants. And with that overview, we'll go ahead and remind folks that if anyone is having trouble with the visual portion of this presentation, you can email events@vitalwaveconsulting.com and we'll assist you in getting into the visual part of the call. Thanks. And Sue, with that, I will turn it over to you for a discussion of the substance of the law.
Great. Thank you, Anne. I think it would be great if we could make this somewhat of a dialogue, so feel free whenever any questions come in, or if you have questions yourself, to pose them during the presentation, because I think that's more interesting, making sure that I cover the aspects that everyone is interested in to the best of my ability. So we are going to talk generally about the FCPA and the new UK Bribery Act. As we all know, the increase in both the increase in bribery happening, as has been documented by the latest Forbes article, that it actually is increasing around the world. At the same time, the increase of enforcement of anti-bribery provisions are either increasing in enforcement and or new acts are being created. So it's an interesting time in this particular endeavor. And Anne, as you mentioned, many of the terms and phrases used in these laws are not quite clear, are somewhat vague and open to interpretation, and we're going to talk about some of that today. So while definitely preventing bribery is a very laudable act that we are definitely trying to do worldwide and would make everything better, make it easier for businesses to operate as well as better for the citizens, these laws can be somewhat tricky to follow or to understand, especially with some of the vagueness and the ever-changing aspects of them. We've had, for instance, new guidance documents and or new acts, major happenings in the last 3 years in at least 4 to 5 different jurisdictions, as well as the standard for how people comply with this is changing over time, and best practices are changing over time as well. So we hope today to give you an overview in particular of the FCPA and the UK Bribery Act, to talk a little bit about the terms and definitions involved in those, to give you an idea of how corporations are dealing with them and the various areas of compliance that they are putting a lot of effort into, so you can understand sort of the current state of the art and the current issues involved in those. But I also wanted to mention that there are, of course, so many other anti-bribery laws that we are not going to cover, and many of them are also increasing in enforcement. I'm sure many are aware of the recent Siemens case, which they were actually prosecuted both in Germany and in the United States, more than $580 million in here in the United States, and even more overseas. And so if you even add the disgorgement, which is returning the profits here in the United States, the numbers look like about $1.6 billion for Siemens. So Siemens was hit both here in the United States as well as in Germany. And so everyone is aware there are different acts that are being enforced, and not just actually country acts, but there's actually entities enforcing them. So the World Bank has really upped its prohibitions of bribery, saying that they will actually disbar companies who they have found to be bribing in some of the government contracts. And I think to date there's been more than 450 disbarments under the World Bank. So this is increasing in so many different areas, but today we're going to concentrate primarily on the FCPA and the UK Bribery Act. The FCPA is the oldest of one of these acts, first enacted in 1977, and still to this day people think of as really the landmark of the anti-bribery and has really set the standard for a lot of these laws. And the other one that we're going to cover in depth is the UK Bribery Act because it's so new. Because it's new, it was enacted in 2010 and entered into effect in July of 2011. And it is said to be even more strict, and we'll talk about why we see that in the law, even though there has yet to be very many enforcement actions under it. But at least the language is broader than the FCPA. So where the FCPA used to be considered one of the most strict anti-bribery provisions, we now have the UK Bribery Act as well. So both of these we're seeing around the world, the increasing interpretations and the increasing of actual legislation being passed, as well as the fact that these are extraterritorial laws, meaning that you can be subject to these laws even if your headquarters are not in that country. So, for instance, the Siemens example was able to be prosecuted in various places. A company, for instance, that would be headquartered in the UK and have a principal place of business in the US, and then maybe some bribery occurred in Africa, could be held under both the UK Bribery Act and the FCPA as potential violations. And given that the standards are a little different, that makes it oftentimes hard for companies to comply or to follow what is the current state of play for the various acts. So on the next page, Anne, we're going to talk a little bit about the three areas here, the Foreign Corrupt Practices Act, the UK Bribery Act, and talk about the violations and going forward. I also wanted to mention two of the other major areas where the anti-bribery provisions are currently being used and adopted by countries. So the first is the OECD Convention on Combating Bribery of Foreign Public Officials. This was actually enacted in 1997. In 2009, more guidance came out with it. So basically, this is another entity where countries that sign on to it actually agree to criminalize bribery behavior. It's supply side focus, what we use that to mean is that it actually penalizes the companies involved, not necessarily the public officials involved. So the aim is on the companies as opposed to the officials. Most countries have their own laws with regard to officials receiving bribes. For instance, the FCPA deals with anti-bribery of foreign officials, and some people have said to me, why doesn't the FCPA deal with bribery of U.S. officials? Well, that's because that's covered by different laws. We have different laws about lobbying and receipts and what public officials can do. So the FCPA really regards foreign officials, just like the OECD, foreign officials, and it is supply side. It is against companies, provisions against companies who may engage or be caught in these endeavors. The other is the UN Convention Against Corruption, which is now has been signed on by most of the UN members, including people of Mexico. It was signed on in 2003 and became effective in 2005. This is broader. It also has provisions on anti-money laundering, and it has broader provisions. Some of the provisions are recommended, and some of the provisions are recommended, and some of the provisions are actually required. And the one that was required is the criminal provisions against bribery. The next page has the list of the members of the countries who have signed on to the OECD Convention on Combating Bribery. This is interesting because, as you note, some of them are non-OECD member countries that have signed on. And you also note that there's countries such as Russia and others that people may think that bribery actually occurs quite regularly there. It's interesting to know that most countries do have provisions against bribery, and they actually have put laws on the books. Whether or not they enforce them and how strictly they enforce them, and whether or not enforcement is actually discriminatory, meaning only against certain companies and not against others, varies per country, obviously. But it's interesting to know that I wanted everyone to be aware that even though we're covering two laws today, you could be subject to many of these laws. Most countries do have something on the books with regard to anti-bribery.
Sue, I think one point that was very interesting that you had mentioned previously was the idea that this is not necessarily limited to for-profit endeavors. Can you spend just a moment talking about that?
Yes, exactly. So most of these laws do not have an exclusion for nonprofits. The way that people would think that perhaps nonprofits have not been involved very often is because it actually states that you have to get a business advantage. Most laws say that you need a business advantage. However, most scholars recognize that nonprofits can receive a business advantage from a government. And so, in fact, it's been talked about quite a bit that we may expect some more, or at least one large case in this area to show people that they are not excluded from these laws. They have not typically been the ones prosecuted or brought after, and probably are not typically the ones most involved in this. But that doesn't mean that they can't be held liable under these laws. They definitely can be. And given the new laws that are coming out in the somewhat hard ways to follow them and comply with them, it's totally possible that we'll see something like that pretty soon.
Great, thank you.
Okay, so the key elements of the anti-bribery laws on the next page, Anne. Basically, it's very similar in almost all of these laws. It is somewhat similar, the general definition. The differences really come into play with regard to how they're being interpreted, what defenses are being allowed, what type of mitigating evidence, for instance, if you have compliance plans in place. Those are different among the various laws. But the general law that is put in place in most of these countries is that bribery is defined as giving a financial or other advantage, so it's not just cash bribery, of course, to encourage a person. And we'll talk about some of the laws are any people, and some of them are only for foreign officials, to perform their job improperly, to gain or keep a business advantage. And those are really the mainstays of most of these anti-bribery laws. So it's really the same sort of thought in theory, and again, laudable goal that these laws have. The more harder part, of course, is how they are interpreted, how they are applied, and how companies can learn to figure out how to deal with them. For instance, the financial payments have been so broad where it's actually been inferred that giving opera tickets to a government official's spouse could be a benefit. So it's construed very widely, very differently amongst these laws. And then the advantage that you get, some people may construe it strictly to, did you get a government contract, a direct business advantage, but others are more broad. For instance, if you had any less cost that made it, therefore, more profitable for you to engage in business in that country, which is obviously very, very wide with regard to both the potential benefit that you're giving as well as the potential benefit that you're getting back can vary widely. We're going to start with the FCPA, just so I can talk a little bit about how that's construed and then compare it to the UK Bribery Act. So the underlined words here are the words that I'm going to focus on with the FCPA, which is giving anything of value to a foreign official with a knowledge of intent that some or all of the gift is for the purpose of influencing the foreign official to assist in obtaining a business advantage for the covered person making the payment. So to give you some background into how the FCPA has been enforced recently, they typically use deferred prosecution agreements, which are agreements that will defer prosecution but still have penalties associated. And the use of these agreements is said to allow them to bring more enforcement actions in a particular case. But because most of the cases are settled with these agreements under the FCPA, there's not a whole lot of case law. There is some, but there's not a whole lot of actual court cases interpreting this. So where that leaves you is that what happens when the Department of Justice or the SEC, who are the two implementing agencies under the FCPA, bring an action, they actually will settle it with them, and they may construe these terms to be very broad. You may not agree that it was particularly bribery under these terms, but unless you go to court to get some clarification of these terms, you may not ever get that resolution. And most of these cases settle just because it's easier for both parties, I think, to settle and go on. So with that, we have the DOJ and the SEC at times taking some pretty wide review of what these terms mean, all the way from value to foreign official, which they've construed to mean even employees of state-owned enterprises, all the way to knowledge or intent. They can infer knowledge, so that basically that if there was something that was what the DOJ calls a red flag, that, for instance, a commission looked higher than it should have in a particular country, and you didn't look into it, then you can actually be inferred to have knowledge because you had a red flag. So all of these terms have been construed very, very broadly by the Department of Justice in bringing this forward. The FCPA enforcement, there are some exclusions and affirmative defenses. And these are not used that often. So the first one is a payment is expressly legal under the written laws. There's been some talk of removing this because there's been really no case and no one believes that a country actually puts in writing that bribery is okay. So that has not been, of course, used. The second one is facilitation of routine grease payments. And this gets a lot of controversy because what does this really mean? How much money can you pay to increase the speed of a permit or a license that's not bribery? A lot of discretion involved in this particular exclusion. And then the last one, which also is somewhat vague, is reasonable real expenses related to the promotion of the product. And what this means is if you're selling to a government, just like you're selling to another entity, you should be able to use reasonable means that you would use to a different entity, meaning invite them to your facility, even if it's in a different country, fly them over. And again, this has been construed very narrowly, at least by the government end, with regard to it needs to be reasonable cost. So it needs to be reasonable air flights, reasonable taxi cab, reasonable hotel. And in fact, what we call here the Disneyland experience is that apparently there's been a lot of cases where people from foreign entities, especially China, like to stop at Disneyland when they come visit a United States facility before going home. And there's been a lot of cases of, well, if that happens and you're paying for it or paying for part of it, then you've gone beyond this. So while there are exclusions and affirmative defenses, again, they're somewhat vague. Criminal penalties are up to $10,000, but they're per incident. And the criminal penalties can be for both individuals and corporations. For individuals, it's supposed to be a maximum 5-year jail time and $250,000. However, it's per offense for an individual. So we have seen cases where the fines have been significantly higher than that, and actually the maximum jail time has been much higher as well. And in fact has been multiple years in some cases, and in many of these cases it's actually a settlement that they've agreed to. So it can be applicable to both corporations and individuals, and the penalties can rise because they're per offense, not just a max cap on it as well.
So we've had a question come in with regard to the difficulty of navigating in a lot of markets where officials expect payment in return for, in effect, doing their jobs, granting of permits and things of that nature. And you talked a little bit about the payments for facilitation being an area of caution. Do you have any further insights that you can offer on that point?
Yes. Well, first of all, what I'd like to say is that this, what they call grease payment exception, which I've never liked that term, grease payment exception hasn't been used in the court system in the United States very often, so it's hard to tell exactly what the courts would say. Basically, the United States has construed it fairly narrowly when they're bringing their actions in terms of what people are allowed to do in terms of grease payments, which is basically just minimal payments, small amounts for facilitation. So if it's large payments, it is not. And that doesn't give you much guidance. However, so what I say is you need to be extremely careful. And I also would say that under the UK Bribery Act, they've eliminated that defense entirely. They do not allow grease payments at all. So if you're in that particular jurisdiction, you don't want to rely upon it at all. So what I would say is that, again, because it really depends upon the particulars of what it is it's for, how much it is, all of those sort of things, that the person seek advice through Vital Waiver or myself as regard to each individual one, because it is a very tricky area.
Great. Thank you very much.
So for the prevention measures, given that for FCPA prosecution falls under the U.S. sentencing guidelines, the various things that are listed that would minimize fines or fees under there are used. So what do people do to minimize the potential that if they get involved in something like this, their company or their individual, what can they do up front to minimize the potential liability? And I've listed a few things under the extensive preventative measures. But what I would say is that this changes over time, that as we see years go by, we are actually seeing more and more programs and requirements becoming sort of the standard. So what has typically been the standard are training of your employees, auditing any of your subsidiaries or anyone who does business overseas to see whether or not there's any payments that look funny or red flags, making sure you have contract provisions in all of your contracts with suppliers and distributors or people overseas, making sure that you've gone through checklists and questionnaires, which are due diligence, making sure that the people that you're hiring overseas that may engage in some of these activities, that you have no reason to believe that they would, that you have policies in place and you have reporting procedures in place as to if someone suspects something, how is it going to be handled within your company. Just within the last couple of years, this has even upped even further to where the current state of art really is requiring your overseas contractors to do annual certifications and to make sure that you have audit requirements in your contracts with your suppliers and distributors overseas as well. So this changes with time, and what's interesting is there's a recent case here in 2012 that actually goes through and talks about how Morgan Stanley had adequate procedures in place. And if you go and you look at that particular case, you get an idea. Now, they had way more than the average company would have, but actually, through some of the cases that happen, you can actually see what is the current state of art with regard to what's expected. But it changes over time is the one point that I would make. Okay, so when we go to the UK Bribery Act, the UK Bribery Act is much broader in what it covers. So first of all, it also covers private bribery. So a UK company, for instance, engaging in bribery of another company. So that's, perhaps, seeking business and giving someone additional monies. Now the question is how much, and will it be held to the same strict requirements that the foreign officials are, where it could be even as minimal as giving gifts to the CEO, like lavish dinners or things like that. So where that will go will be interesting to watch. But so the first way it's broader is it actually covers private bribery, not just foreign bribery, foreign public officials. The second place that it's broader is it actually has an offense for failure of the commercial organization to prevent bribery. So that means that it is your duty to prevent bribery. And the way that you can actually get out of that, the defense, is to show that you have adequate procedures in place. So this is really a strict liability law where you can be held liable for not having adequate procedures in place unless you show that you did. You can be held liable for having bribery occurred unless you show you had adequate procedures. So this is interesting because while we talked about under the FCPA, the current state of the art is to have various procedures in place at your company to minimize your exposure if something were to happen or minimize your liability. What the UK did is actually say, if you fail to prevent bribery and you show us that you had adequate controls, then you will not be held liable. So it took it one step further in that the defense would be completely off. Under the United States, it really can minimize your potential liability. The UK, it can actually get rid of your liability. So what's interesting is how this will play out. On the next page, we actually have a list on the right-hand side that talks about the strong documentation. And that's the list that the UK has actually said, these are the things that we want you to have in place if you are going to actually say that you have enough procedures in place to prevent bribery in order to raise to the level of the defense. So a lot of it is the same sort of things that people are doing now under the FCPA. Top-level commitment and policies and procedures, monitoring, review. They add risk assessments, due diligence, which, again, some companies in the United States are doing as state-of-the-art anyways. So it'll be interesting to see if these two laws really collide together where we really end up having sort of one state of play with regard to what companies can do that would be satisfactory to the U.S. as well as the U.K. Again, under the U.K., it's a complete defense. Under the U.S., it's really to minimize the potential exposure. And there has been a lot of discussion in the United States about modifying the FCPA to have an exclusion like this. In fact, the UK Bribery Act, when it was passed, people in the UK actually said It's almost impossible to prevent bribery 100% in a company, but instead what we want people to do is put in place the best procedures they can to prevent it, and that's the best we can hope for. So this is what the UK put forward, and we are now, will be over time, figuring out what they mean by what is a good enough risk assessment, because it will obviously depend upon which countries you're involved in, the size of the company that you are, and the type of markets that you're involved in. So we'll see over time of how this plays out, but it's similar to some of the things now going on for the U.S. companies under the FCPA.
Sue, can we back up for just a moment? We had a question come in with regard to the jurisdiction question,
oh,
and
sure.
the fact that these laws are extraterritorial. And I'm wondering if you could spend just a moment. I know that this is a particularly vague and hard to understand area of the law, and if you wouldn't mind just spending a moment discussing that, that would be helpful.
Sure, exactly. And this is actually another one of the areas that is extremely broad in international law. It's hard to get sometimes jurisdiction over companies that don't have presence in your country. And these laws try to do that. So in the FCPA under the United States law, we have basically construed it very broadly, where it's if you're a U.S. citizen, even if you're operating overseas, if you're a U.S. resident, and you commit bribery for your particular company, then again, the company can be, you and the company can be held liable. A U.S. visitor, that if you commit bribery while you're here. A U.S. corporation, of course. Any foreign subsidiaries where a U.S. business owns more than 50%. Any place with a principal place of business in the United States. And any place where any of the officers that are part of the company reside in the United States. So it's been very, very broad. Now, with regard to UK, so you can see that you can get many companies, especially if they just have a principal place of business in the United States, has been one of the main ways that they can do that. The UK, it has actually the slide that you have up right now, Anne, talks about, there's actually two different standards. So the first one, the prohibit offering and receiving of a bribe, actually the definition of a person is someone with a, quote, and this is the actual language in the law, close connection to the UK. So while that sounds broad, they do list what it would include, but not that this would be the only list. So British citizens, British nationals living overseas, persons that are ordinarily resident in the UK, so people that typically reside there, and companies incorporated under the laws of the UK, which would include subsidiaries and things like that. So, so that is, again, fairly broad. We'll see how broadly it is going to be interpreted as we go forward. And then the second offense for the failure of commercial organizations to prevent bribery applies to both companies incorporated in the UK and a company incorporated outside the UK but conducts business in the UK. So that's the standard for that. And again, somewhat vague words. What does conduct business mean? How minimal or how maximum can that be? So given that this is so new, we'll see where that goes. But you're right to know that under both of these laws, the definition of who they cover is extremely broad.
Great. Thank you very much, Sue.
Okay, so these are just additional UK Bribery Act issues that I just list that are currently being discussed around. So one is no intent required. So again, this is a strict liability statute, but you have the right to show that you had adequate procedures in place as a total defense. There is questions about what procedures are adequate. What is that really going to mean? So that if a company is putting together something in place, what really will that mean? What is a public officials? There's a question there with regard to executives of state-owned enterprises. And this is an issue in the United States as well. The Department of Justice and the SEC have always construed state-owned enterprises and the people that work for them, for instance, a bank or a hospital that's state-owned, anyone that works for them to also be a government official, but that's being questioned. So it's not clear under the UK Bribery Act where it would fall off. And here in the United States, we have, for the first time in the 11th Circuit, a appeal on this issue. And so it is someone who was convicted of bribery with telecommunications, which was a state-owned entity, and is appealing on the basis that that state-owned entity employees should not be public officials. So we may actually have a court case here in the United States soon about whether or not that falls in place. But that's also an issue under the UK law. Again, we always have this vague. We had the good question earlier. There's always a vague area of paid hospitality. The UK gives a little more description that they actually think that you should be able to treat the government people same as a private entity with regard to how you would try to sell to them. So, but it's still not clear exactly what that would mean. I mean, would that mean it's okay to take someone to the baseball game, and would it not? So how that plays out will, again, is somewhat vague. And then the UK laws encourage self-reporting. That's also another factor in the United States law. If you self-report, you're supposed to get leniency. One of the last cases this year, in 2012, where someone self-reported, their fine was reduced to 33%. Some people say that's not enough. Some people say that it is. But the question is, if you do self-report, how much credit should you be given? And the judges in the UK basically say that they still think that criminal penalties should be applicable even after self-reporting. In the United States, we still do have penalties after people self-report, but it reduces it somewhat. And the question is always how much and what is the right amount that should be. The other point that I wanted to make is third-party liability and exposure. Most of the FCPA cases that we see, majority of them are done by third parties. So it's third parties acting on behalf of the company. So it's not the company itself or the employees of the company that are engaging in bribery, but it is a company or an agent or a consultant or someone who they've hired that is actually engaging in the act. And so this is what is so interesting, and this is why it is hard and why UK actually flat out said it's almost impossible to prevent bribery 100%, which is why we're giving the defense of if you have adequate procedures, is because it's very difficult for companies to control or have that much say over their contractors overseas and what they're doing. And so this is one area which is why it is hard and tricky, and which is why companies really do want to go the extra mile and make sure that they put all the mitigating steps that they can at their company to minimize FCPA liability, and or if UK Bribery Act applies, in order to qualify for that defense, because this is the area that unfortunately companies have the most exposure, because it is very difficult. And under the United States law, basically if you see any red flags, if your consultant's fees come in too high, they give you a receipt that just says commission and it's pretty high. You're supposed to do an audit on it. We have a couple of cases where you've seen enforcement of these issues where the United States looks at them as red flags that the company should catch. So this is really the main area that most companies have the most concern about, and this is the hardest area to actually control. And this is why there's a lot more contract provisions, a lot more audits of their contractors. There's provisions in their contractors' contracts that say that the contractors can't hire subs without okay, because you don't want your contractor then hiring a subcontractor who you have no idea who might be engaging in bribery as well. So because of that, that's why we've built up this really pretty in-depth compliance plans and policies that have been changing and getting better and better over time, more state-of-the-art over time, at the same time that the UK has come out with its affirmative defense with regard to adequate procedures, is because it is very difficult. This is really the hardest issue is with regard to third-party liability and exposure.
So I think that this is a particularly important point because of the third bullet on this list, that you do not have to actually have control over the actions of a third party, and yet you can remain liable for their behavior.
Exactly. Exactly. Now remember, again, the standard in the United States is knowledge. And if you go to the next page, which is some of the hot topics, one of the hot topics is mens rea, which is state of mind. You know, the law in the United States FCPA says that you knew, that you had knowledge of bribery occurring. And however, it's been construed to mean that you basically, if you see a red flag, you, quote, will be assumed or knowledge will be implied upon you. So the mens rea has gone down quite a bit. So you have no control over your contractors, and yet you could be held liable for them even if you don't know what they're doing. However, if the government believes that there was a red flag there, that means that you consciously disregarded or you consciously avoided looking further into it, then you will be assumed to have knowledge. So basically, conscious avoidance is knowledge. The question is, you know, should have known even stretches conscious avoidance further. And, you know, what exactly is the standard? with regard to potential liability under the FCPA. It says the word knowledge, but it's being construed much more broadly. And that's the big issue with regard to third parties, because, again, you can be held liable without even directly knowing if there was a red flag there that the government believes you should have looked into. So some of the other issues on the hot topic, I had mentioned that there is a telco case with regard to what is the definition of a foreign official under the FCPA and whether or not state-owned enterprise employees will still be considered to be government officials. The conformity issue, whether or not we will actually be able to conform where there is one standard that the companies can adhere to, even though these laws are different. For instance, we talked about facilitation payments being okay in the U.S., not okay in the U.K. We talked about that there's perhaps different standards of how you defend or how you put together compliance plans. But I think over time we will probably meld toward a common standard just because we have so many multinational companies out there. But right now there is no complete consistency amongst how these are being both drafted and being enforced in these various areas. There's been a lot of talk of FCPA reform. There is supposed to be a new document, guidance document, coming out on the FCPA this year. There's been some talk of perhaps having a complete defense like the UK law has, where if you have adequate procedures in place, you should be fine, just because the liability for the third parties is so hard to control. But now people have said with the new Walmart's potential case down in Mexico that the appetite for maybe changing the FCPA is not as great right now as it once was. Another thing that's happening is people are taking more of these cases to trial. So as I said, most of these cases, at least under the FCPA, have been deferred prosecution agreements that people are now taking them to trial. And we've had a couple courts actually throw them out, throw out cases, and a couple of jury who acquitted someone and a judge who said that the prosecution acted improperly and threw out a conviction as well. So that's adding an interesting twist into this. But it would be helpful if some of these laws, because it would help define these definitions further. Since not a lot of them make it to court, most of them are settled, the definitions have continued to be somewhat vague, as we've talked about, including, for instance, facilitation payments and where exactly is the line, or reasonable accommodations when you can actually bring a foreign official over to visit your facility. Where are the lines? And without a lot of court cases, it's hard to tell that. So that will be interesting to watch as we go through. And last, the newly opened economies and the new markets like Myanmar, where bribery is listed as, I think Myanmar is now listed as the #2 country on the statistics with bribery. But at the same token, we're opening up for business, and so we're having, I think, it's a harder time on companies to comply with, again, going more and more into some of these jurisdictions where bribery happens. At the same time, new laws are being passed or being more strictly enforced that may not be as clear as we would like them to be. So it's an interesting time for companies. And again, while this is a great laudable goal, I think it would help everyone worldwide if bribery went away. It is different. We're in a stage now that we're still trying to figure out what are the right definitions, what are the right affirmative defenses, and how can we get this right so that it's fair on the companies that are trying to do their best, but at the same time it's tackling those who actually are engaging in bribery.
Great, thank you, Sue. We did have a question about how to monitor the status of anti-corruption and anti-bribery legislation in emerging markets. We did have a list of the OECD signatories, some of which are emerging markets. But is there a central place to monitor these developments, or is that part of the challenge that companies face today, that there really isn't a central repository for information?
That is actually one of the challenges that the companies face today, too. So there is not really a central repository. There are a few places out there. There's a few professors, actually, that have compliance and ethics blogs and try to keep people up to date. But it's not an official place that you can actually go there. And even those, I don't think cover everything that you would want to know. So that's definitely one of the large challenges here.
Right. Thank you. So with that, I think that we have answered most of the questions. There was one additional question with regard to whether or not there are specific countries where doing business in those countries draws the scrutiny of regulators either in the U.S. or the UK. I'm not sure a list like that would be widely known. Are you aware of specific countries that draw scrutiny beyond normal levels of scrutiny?
Well, there's been definitely a lot of cases across the board. So I would say that you see them everywhere. So I'll put that out there first. You see them in lots of African countries, you see them in lots of Latin American countries, and you see them in lots of Asia countries. And maybe it's because of the size of the country, but you do see a lot coming out of China and Russia, but they're actually pretty large. But you see just as many India. You see them all over. So I can't readily say that that necessarily that anyone should think that there is one particular country that's definitely scrutinized, way above all the others.
Great. And we had another question come in, and Sue, this will go to your prior life in government affairs, but what specific challenges should companies be aware if foreign government officials visit their facilities?
So what should they be aware of if a foreign official visits their facility?
Right.
Yes.
What are the potential pitfalls there? I imagine that there are some.
Yes. So if they visit your facility, fine. You will want to know and be aware of, are you paying for anything for their visit? Are you paying for their transportation, their hotel, their air flight? And do you feel comfortable that it's within the reasonable realm of what you would need? And again, I think you should get someone's advice with your particular situation. So you want to be aware, are you paying for anything for their visit? Cars, hotel, airfare, or whatever. And you also need to be aware of, this is another issue, is gifts. So in a lot of these visits, people expect to give gifts to the foreign officials. And it needs to be something reasonable. So some things that the companies have done are like baseball caps with their name or pens with their names. If it's something, a little more substantial, you'll just want to, again, get that check to make sure that you feel comfortable with that. And so it's almost gotten to be an issue with people all the time. I'll be at a meeting and someone will say, we wanted to give you more, but under the laws, this is all I could give you. But so people are ratcheting down some of the gifts in order to make sure that they don't have an issue there too. So those are the main things that I would be aware of if you had a foreign official visit your facility.
And I think the point about transportation too is quite a good one, because it would be customary in many cases to send a car to a hotel to pick someone up to come to your facility, and you need to be aware of any nuances around that behavior.
Exactly, exactly. And there are some law firms and lawyers that would look at it and say, don't use limousines, use reasonable. But again, it really depends upon the circumstance and the situation, and it's really individualistic. But what I would say is if you are paying for any of those, you definitely should look at it and make sure you feel comfortable.
Great, thank you.
Fit within the laws.
Last question that's come up here before we close. Is it ever possible to hire a foreign government official, or is that something that needs to be given particular scrutiny or perhaps avoided altogether?
That's a really good question, Anne. And in fact, I need to make this point too, is that the other way you can get more information under the FCPA and some of these other laws is to actually seek an opinion. So you can write in a potential hypothetical or situation and seek an opinion, given that these laws are somewhat vague and given that you don't have a whole lot of court cases actually interpreting them or telling you with a bright line what is right and what is wrong. There are a couple of opinions, for instance, on the hiring of a foreign official under the FCPA. So this has come up a lot. And I would tell you that the answer to that is yes, sometimes you can hire a foreign official. There's a lot of hoops to jump through. You need to make sure that you then also aren't being given a business advantage. So there's a lot of, and there's at least 5 or 6 opinions written on this, I believe, that talk about, you have to make sure that it's out in the open, that you really aren't getting a business advantage, that this guy does this regularly, that his supervisor knows. There's a bunch of hoops to jump through, because the main intent is, again, the intent of the law is supposed to be you're giving money to a government official to get a business advantage. So if that's really not occurring, then it should be fine. But the problem is that's such a gray line. People really, and I think rightly so, before you hire a government official to do something for you in a different capacity, I would definitely have someone look at it and make sure that you feel comfortable that you fit there. So the answer to your question is it's possible, but there's a lot written of what you really need to do to have proof in your file that this is completely above board and not a bribery, and you're not getting a business advantage for this.
And Sue, I imagine that this is also true in terms of hiring consultants in foreign markets, that you need to be particularly careful that the consultants that you hire in foreign markets or other service providers with whom you do business in foreign markets determine if they have government officials on the payroll and do some due diligence around that area.
Yes, yes. And also the definition of government official can include parties. So being a member of for instance, a leader of a party, which someone can do in their spare time, not necessarily as a full-time job. So there's, or, you know, you can be, it also includes, for instance, employees of government organizations, not NGOs, but government organizations, so the UN and others. So the definition is pretty broad, and which is why due diligence has become a big piece of this, is because you really need to find out more than even their day job may not necessarily tell you that they're for sure not a government employee, or, you know, and as we know in many countries, people have both business cards and government cards, right?
Right.
So to do some due diligence to see if they actually are, and in any of the categories currently being considered to be a government employee.
Great. Well, listen, thank you so much for an informative discussion of these interesting and, I have to admit, slightly scary topic areas. That said, I wanted to close on a note that Sue and I are happy to talk with you individually if you have any additional questions. My email address and telephone number are listed here, and we're happy to talk with you about training and compliance programs, monitoring and evaluation, and due diligence and risk assessment that is necessary for doing business in key emerging markets. And with that, I think that we have answered all the questions, but again, please do feel free to contact us for follow-up if you have any additional needs for information in this area. And with that, Sue, I would thank you for your time, and to the participants, thank you so much for joining us this morning. And we're going to go ahead and sign off.